Relatives, friends, and in-laws, good afternoon. I'm told that you cannot say now, ladies and gentlemen, because there are other genders or identifications that might be left out. So allow me to call you relatives, friends, and in-laws. Good afternoon. I am indeed very humbled to be given this huge task to be a keynote speaker on this very important day. When I was invited, I thought to myself when I saw the guest list that you have a person who took part in making this constitution. You should have made her a guest speaker or a keynote speaker. You have somebody who fought to deliver the peace that this country enjoys in Raboni. I thought they should have made them keynote speakers. But I quickly realized that my role was not really to go into a very extensive discussion, but rather to be the chief provocateur, to provoke discussions, to tickle your minds, to discuss this very important topic. But before I do that, let me apologize for the manner of my dressing. Those of you who know me know that normally I wear a suit. But as you can see, I'm limping. My ankle is twisted, and I can't wear shoes. So I figured out, instead of looking like a clown in a suit and open shoes, I would rather come dressed casually. So I apologize for my manner of dressing. Secondly, let me apologize to the discussants that I should have shared my paper with you. But the call for me to be a chief presenter here came rather late, and I wasn't able to sit down and put my thoughts together in a coherent manner that I could share with you. But I take comfort in the fact that many of you are non-debaters, that even if I woke you from your sleep, you would have something useful to say. When I saw the name of the Honorable Pono Pondo, I thought, even if he wasn't a lawyer, he would always have something to say. But I was disappointed he never came, but even his replacement is equally robust. Madam Sarah is also a very astute debater. So I'm sure they will discuss what I'm going to say here really very well. I was asked to talk about the topic celebrating 19 years of the 1995 Constitution. What are our constitutional gains and what are the proposed reforms? Now, it is not news to all of you that today marks exactly 19 years at a very colorful event at what was then known as the Constitutional Square. The new Constitution was given to the public in what was seen as a new beginning for a country that had for a very long time had problems of unstable constitution or the lack of rule of law. So that constitution gave people a lot of hope. Some of the things that were said when this constitution was enacted and finally promulgated were very colorful. People like Justice Benjamin Odoki, forget who he is now, but what he was then, called this constitution one of the best in the continent, infused with what he called principles of human rights at every turn. People like Justice Kanyahamba, again, forget who he is now, at the time, one of the key brains in the discussing of that constitution, called this constitution perhaps the best gift that the NRM government had given to the people of this country. But 19 years later, if this constitution was a girl, she would be above the age of consent. If it was a boy, he would begin to have grown beards by now. He would be a mature person, ready to be a productive member of our community. But is that constitution that person we hope it would be 19 years ago? Colleagues, I want to submit that in 19 years, 199 provisions of this constitution has been amended. In 19 years, 199 provisions of this constitution have been amended through different amendments in the year 2000 and 2005. While it is true that constitutions must stand the test of time and must reflect the obtaining aspirations of the people in the country, amending a constitution 199 times in 3 years, in 19 years, in 3 different amendments, doesn't speak of a constitution that is durable, that is stable, speaks of a process to manipulate, in my view, what was supposed to be a governance consensus for the people in this country, especially given the process through which that constitution was arrived at. So in terms of where that constitution is, if this constitution met the one that was enacted in 95, perhaps they would not even know each other. Because what we have now is a completely different document that has been, in my view, hugely altered. The national consultative process that people like the Honorable Matembe went through to arrive at this constitution was quickly disregarded even before the ink in which they wrote it dried. But that said, that constitution is not in vain. We have had several achievements that have been brought in place because of the enactment of that constitution. Allow me to just highlight them, lest I'm accused of being dishonest. First, the 1995 constitution ushered in my view, a period of relative stability in the economic governance of this country. For the first time, you had institutions like the central bank that were insulated, at least in theory, from the overbearing influence of politicians, especially those in power. That in many ways has translated into relative, and I use the word relative deliberately, economic progress and stability for this country. You may disagree, but that is a fact, that the economy of this country and the stability it enjoys has a direct link to the constitutional governance of this country. The second gain that I think was significant is putting in place institutional frameworks for the governance of this country. You have new institutions that were put in place by the new constitution, and again, don't worry about how these institutions work or their deficiencies, but the fact that they are actually there is a good thing. You have a Human Rights Commission. For the first time in this country, a Human Rights Commission mandated to investigate violations of human rights has been put in place. You have institutions such as the Inspectorate of Government that initially was empowered to investigate human rights but subsequently became an anti-graft institution. You have a fairly stable judiciary or judicial process. At least we have a court of law that you can go to when you have any grievances, and occasionally you actually get very good decisions coming from those courts. Lastly, there have also been some form or semblance of rule of law. My good friend and your lecturer, Dr. Kabumba, would say rule by law, but I would want to suggest that at least there is a semblance of a rule of law. It may not be what we want it to be, but at least you have laws that have been enacted to ensure that the rules of the game are clear. When you want to go and sue an individual, you can go to court. You have processes that bring confidence that at least Uganda is governed by some form of rule of law. You have now magistrates courts in every country, in every county, in every district in this country. But the gains notwithstanding, the 1995 Constitution has not lived to its promise. And I want to suggest for the following reasons. First, that there has been incremental and gradual and incremental clawing back on the achievements or on the provisions of that constitution through what I think are enactments of retrogressive legislations intended to remove, as opposed to empower, the enjoyment of fundamental human rights provided for in Chapter 4 of our Constitution. Some of the examples of these legislations include, for example, the Public Order Management Act, a law that is presented as one that is intended to regulate public assemblies, but in fact, it is a law that tends to defeat, as opposed to facilitate, the enjoyment of the right to peaceful assembly. You have other legislations, such as the Anti-Pornography Act. And I know that you get excited about this law if we mention it, and you think about pornography. And indeed, pornography is not good for this society. But in fact, the actual letter of that law is intended to clamp down on personal and individual freedoms of expression, beyond just your manner of dressing or what you watch on your smartphones or your tablets. It is intended to constrict or restrict the use of the internet, the use of new media, the use of other social media platforms. If you look at the letter of the law, that is the intention of what they want to do. The other one is the NGO Amendment Act, again intended to restrict the enjoyment of the freedom to associate and to assemble. These laws, in many ways, have significantly clawed back on the beautiful provisions of Chapter 4 of our Constitution. And in many cases, these laws are passed through processes that are suspect. All of you know that MPs are given money each time an important legislation comes before the House for passing. That even if those legislations are illegitimate in their own nature, members of Parliament are quick to go to a caucus meeting and endorse those legislations. So I think in many ways, the clawback in the enjoyment of fundamental human rights expressed in not just passing of laws, but also actions of government institutions in wanton disregard for fundamental human rights have made the dream or the dreams of that constitution to wither away. The second pitfall, and I say this with a lot of pain in my heart, is the deliberate attempt to demobilize accountability institutions. You create institutions, but actually make them ineffective in a way that even if they want to express themselves and, in fact, do what they're supposed to do, they cannot do it. And I'll give you just two examples. And the first one was mentioned by the Honorable Opio is the courts of law. For close to now 2 years, this country has not had a Chief Justice. This country has not had a Deputy Chief Justice. Justice Stephen Kavuma is not, legally speaking, a substantive acting Deputy Chief Justice or acting Chief Justice. In any country, for a third arm of government that is as important as the legislature and the executive, the judiciary is viewed in very serious light, so that every attempt is made to make sure that it's functional. In Uganda, the judiciary has been, as described by the Honorable Principal Judge, a fatherless institution. And I think the tendency has been to look at the Chief Justice, but if you look at the entire judiciary, you realize, for example, that we haven't had a Supreme Court fully constituted for the last 10 years. We haven't had a Court of Appeal or Constitutional Court fully instituted for the last 10 years or so. We haven't had, even the High Court still has vacancies. Even Chief Magistrate Courts still have vacancies, including the registry. So the process is not an accident. In my view, it is a deliberate attempt to demobilize the judiciary and deliberately make it weak. No wonder then that when the Chief Justice retired, there was every attempt to twist the process to have him reappointed as an acting Chief Justice. Secondly, let me give the example of the Inspectorate of Government. A beautiful institution, normally the pride of every government to show that this government is accountable. But you have an Inspectorate of Government that is created and for, I think, about 8 years, not fully constituted. An inspectorate that, in spite of being now fully constituted, has had to deal with problems of inadequacy of resources to implement its own function. So I think that these structural weaknesses of institutions that eventually then make our constitution and the promise it gave this country really an empty promise is one such example of how that constitution has not, in my view, lived up to its original promise. And you've got to go back to the preamble of this constitution to look at what I think were the thinking of the CA delegates when they were discussing this constitution. They thought that this constitution should be a durable constitution. The question then is, 19 years later, is this constitution a durable constitution, given the different mutilations it has gone through? They envisaged that our constitution should be a constitution that delivers on the principle of unity, peace, equality, democracy, freedom, social justice, and progress. The question is, has this constitution delivered on all of those principles? I suggest it has not. Therefore, what then needs to be done to be able to go back to the promise that this constitution, in the very first place, gave this country? And these are ideas for reforms that are being discussed all around. But before I say that, let me just make the following points. First, that the tendency in this country is to try and think that for every problem we must enact a law. Okay? I was joking last week in a meeting that Uganda is now a law factory. That Parliament has now been reduced to an assembly line of laws. So if there's any problem, you've got to go and ask for laws. In the same breath, the discussions around the reforms of our constitution must not in any way be confined only to a discussion of the letter of the law. Because in my view, and this is strange coming from a lawyer, the problem is not the law primarily. Rather, it is a problem of a lack of culture of respect for the rule of law. We must first and foremost begin to address the problem of the culture of disregard for the rule of law. And then there are many ways you can go about that. But in my view, the first thing you have to do is to make sure that you have an empowered society. Make sure that you have a society that is able to link the problems in their different villages to the governance of this country. For example, my grandmother in the village should know that her roads are bad, that the schools in her village are poor, that there are no medicines in hospitals, primarily because of a governance deficits. And once we begin to link that to the governance issues, then we can talk about reforming the laws and making sure that the laws serve the interest of the people of this country. But let me go and discuss these constitutional reforms. And I discussed these constitutional reforms with the benefit of having seen last night the government proposals for constitutional amendments that was submitted to Cabinet about 6 days ago. The first proposal that is, in my view, urgent for this country is a proposal that relates first to the economic governance of this country. You can talk about other reforms, but for as long as the guy who holds the purse in the central government, in particular in the central bank, is still, in terms of his own independence, unable to exercise independence and still subservient to the ruling government and in fact the whims of an individual, then you have a problem no matter what laws you have. There have been discussions around the public finance bill to talk about oil revenues, to talk about Uganda's wealth in light of the discoveries of minerals in this country. But all of that is meaningless if you cannot have credible reforms on the economic governance of this country. And that reform must start first and foremost from the central bank. Because what the central bank has been doing over the last couple of years is to allow the government to go and just take money and spend. And then the bank's role has been reduced to simply sweeping off excess liquidity to control, to control inflation in the country. We are the only country in which inflation rates remain relatively in the same bracket. And if you look at that critically, you discover that that is a problem of the governance of our central bank. So in my view, that has to be a primary function that the reforms must address. Secondly, I think that beyond the economic reforms, there are discussions around some
the microphone has gone off. I think because I was going to political reforms.
I was going to begin discussing political reforms. The second batch of reforms, in my view, that has to be seriously addressed is political reforms. These political reforms will take various shapes. First, there's the question of the credibility of the electoral process. And the credibility of the electoral process is a discussion that needs to go beyond just replacing the 7 commissioners of the Electoral Commission. Of course, that's important. But I think that we need to focus on the entire electoral process. How credible an electoral process can be once we have elections, how elections can reflect the popular wishes and wills of the people of this country. So there are going to be there are going to be reforms in the area of, one, independence of the Electoral Commission, to ensure that the Electoral Commission is purely independent. And I can tell you, and don't ask me for the document because I won't give you, that the most significant proposal in regards to the EC that government is proposing in its proposal that was submitted to Cabinet 8 days ago is to simply change the name of the Commission from the Electoral Commission to the Independent Electoral Commission. I think that independence of the EC goes beyond name and goes to the question of the process of appointment, goes to the security of tenure of members of the Electoral Commission, goes to the question of the management of the elections, beyond just the 7 commissioners who sit at that warehouse in Ginger Road. The second reform in that light, in my view, must be an honest discussion on the role of the army in politics. Because for as long as Raboni's friends haven't disabused themselves from the Bush mentality, the perception is that our democratic values or governance is actually being secured not by the Constitution but by the army. And therefore every decision in the governance of this country must be vetted by the army. Even elections have to be superintended by the army. But the army has to sit even in parliament to decide laws that will be enacted. I think we've got to have an honest discussion about the role of the army in the politics of this country. Whether we shall confine the army to the barracks for the role of defending this country, or we shall have the army as an active participant in the politics of our country. The third proposal, in my view, has got to do with the power of the imperial presidency. And I think Honorable Chikamia would be very happy to hear this, that I do share with her the view that the presidency has too much power in this country. We've created an imperial presidency, so much so that every appointment almost in this country has got to be done by the president. We've got to have an honest discussion about the power of the president, especially in regards to issues of the governance of the economy, issues of the appointment of constitutional bodies, issues of his role in the army. These discussions must be had in an honest and open way. But more importantly, we also have to have discussions for reforms around the Bill of Rights. Because Chapter 4 of our Constitution has been stressed and strained over the last 15 years, so much so that now, if you cite for a policeman simply, Article 34, you will say, what is that? I have orders from above. We must have discussions about certain fundamental rights in our Constitution. First of those rights, in my view, should be social and economic rights. Because Uganda is perhaps one of the few countries in which social and economic rights are merely relegated to areas of national policy and directives of state principles. In my view, we need to legislate concretely on social and economic rights and perhaps make them the body of rights contained in Chapter 4 of our Constitution. There are also other right issues such as civil and political rights, the right to assemble and associate, for example. We must go back to the drawing board and re-examine the laws that have been passed that restrict the space for enjoyment of civil liberties, especially association and assembly. That political parties must be able not just to exist, but to raise money from whoever they want to, but also at the same time be able to organize in order to challenge the power. So we must examine, in my view, the laws that govern the organization of political parties, the financing of political parties, and how they relate to the people in this country. For example, I want to have perhaps a discussion around a political party being able to go to a village without necessarily getting clearance from the RDC or the DISO in the district. We must have this discussion if we are to have good governance in this country. Lastly, and by no means least, and I could have gone on forever, is that we need to have an honest discussion, in my view, on the question of separation of power. How can we safeguard the independence of Parliament? How can we safeguard the independence of the judiciary? Because the judiciary and Parliament are really the institutions of governance that have suffered the most. The judiciary, for instance, has over 70% of its staff members employed by Public Service Commission, employed by other arms of government, and yet they have to work in the judiciary. Clerks, interpreters, stenographers, drivers, and everybody else that you have first contact with in the courts are not directly governed by the judiciary. The judiciary is financially still dependent on the executive. So we must have discussions about empowering institutions of governance and giving them the independence to exercise their role and function in order to ensure that the constitutional order that is delivered by this constitution is actually protected. Because in the absence of those safeguards, you really have nowhere to go. And just look at the 9th Parliament. Is that Parliament considered to be an independent Parliament? A Parliament in which nearly 100 people belong to the executive. So for any vote that comes in Parliament, you have nearly 100 votes. Even if it is rejected, you have 100 votes from Cabinet, and they all have to sit in Parliament. We must re-examine the role of Parliament, the role of the executive, and the independence of the judiciary, critically in the electoral reforms that are being suggested. Those are the brief highlights of my presentation. I'm sure that people who are involved in the actual campaign for free and fair election, like my own brother Norbert here, will talk in detail about some of the proposals that are being suggested. But I thank you for listening, and I look forward to a fruitful discussion this afternoon. Thank you very much.